Here's Ms. Sikorsky. Members before the court for a pretrial conference. The same is being conducted via Zoom. Present is Attorney Maria Sikorsky representing the plaintiff Charlene Ryder. Ms. Ryder appears to be present with Ms. Sikorsky. In addition, Attorney Alexis Spencer is present representing the defendant Michael Ryder, and Mr. Ryder is present with Ms. Spencer. Good morning, everyone.
Good morning.
Good morning.
Ms. Sikorsky, I believe you're muted.
No,
Okay.
I don't think.
Oh,
Can you
there.
hear?
Okay, we couldn't hear you initially. That's much better.
Oh.
I couldn't hear you. In any event, the court's recollection is we're going to take the proofs this morning, and the parties were in the interim going to secure a mediation date for Attorney Godfrey. Is that correct?
That is correct, Your Honor.
That
And
is
we did a mediation date of August 22nd at 9 a.m.
Oh, you might cannot hear. We have a new sound system in our courtroom. It's just I can hear if you're way in the back of the courtroom, so that's why I'm having difficulty hearing Ms. Sikorsky. We're going to see if we can turn up the volume here. I'm sorry. When again is the mediation date?
August 22nd at 9 a.m.
August 22nd, 9 a.m. Thank you. So to be the intent of the court, and perhaps the parties, attorneys can explain to the parties, the court has a time performance guideline, or I have to adjudicate cases within a window. So by taking some basic testimony this morning, establishing jurisdiction has been a breakdown. The court will reserve all issues, and then schedule a pretrial conference subsequent to the August 22nd 9 a.m. mediation with Attorney Godfrey. So with that, Mr. Ryder, can you both please raise your right hand to be sworn, please? Thank you. Okay. All right, Mr. Sikorsky, if you can meet with Ms. Ryder, please.
Yes, thank you. And speak up so that they can get your testimony, okay? Would you please state your name for the record?
Charlene Marie Ryder.
Remember signing this complaint for divorce on January 8th of this year?
Yes,
And did you read it before you signed it?
yes,
Was it true that you'd been a resident of the state of Michigan and the county of Monroe for 180 days?
yes,
And you and Mr. Ryder have no minor children, is that correct?
correct.
Are you pregnant?
No,
Has there been a breakdown of the marriage relationship?
yes,
Have the objects of matrimony been destroyed?
yes,
Is there any likelihood that this marriage can be preserved?
no,
Thank you.
Ms. Spencer, I'm sorry, did you confirm with her? Did you confirm with her she's not now pregnant?
I did.
All right,
She's
thank
not.
you. Thank you, Ms. Sikorsky. All right, thank you. I missed that. Ms. Spencer, do you have any questions, Ms. Ryder?
I do not. Thank you.
All right, no questions asked of Mr. Ryder other than if you wish, Ms. Spencer.
Yes, thank you. Can you please state your name?
Name is Michael David Ryder.
Okay. And is it true that you were a resident of Michigan when she filed the complaint?
Yes,
Okay. And is it true that you guys have property, both real property and personal property, and debts as well that need to be divided?
yes,
And were you able to read the complaint for divorce that was filed?
yes,
Okay. Do you have any questions?
no,
Okay. Nothing further. Thank you.
Thank you, Ms. Spencer. You don't have any questions, Mr. Ryder, do you, Ms. Sikorsky?
I do not. Thank you, Judge.
Okay, the parties will engage in discovery. Have the financial affidavits been exchanged?
They
Yes.
have.
Thank you. All right. If in fact there's some resolution in the interim, the court will always be available, as you know, but in any event, based upon the testimony that's been presented this morning, as well as plain file, this case court finds that jurisdiction has been established. Court further finds, based upon the testimony of Ms. Ryder, that there's been a breakdown of the marriage to the extent that the obviously match already been destroyed. There's no reasonable chance of reconciliation. At this point in time, the court will simply reserve all outstanding issues. Order that the parties engage in mediation with William Godfrey on August 22nd, 2024 at 9 a.m. and subsequently appear before this court for a continued pretrial conference. Court will mail out notice. Anything further this morning, Ms. Sikorsky or Ms. Spencer?
No, thank you, Your Honor.
All right, Mr. Ryder, have a good rest of the day. That will conclude this hearing. So you can now zoom out. Attorney Gerald.
Thank you.
Dean Trout. Good morning, Ms. Trout.
thank
Good
you.
morning, Your Honor.
In addition, the plaintiff Elizabeth Johnson is present. Is
Good
Robert
morning.
Johnson present? Is Robert Johnson present on audio? It appears that he is not. Ms. Johnson, have you attempted to text to reach out to your husband, Robert, this morning?
I did. I just texted when they asked me to at 9:35. He has not
No
responded.
response?
No.
Okay. And as far as you know, your husband still resides on the Francis?
No, actually, I went by there the other day and he is vacated. I have no idea where he's at.
Okay. When's the last time you had contact with your husband?
I'd say about a month ago.
Okay. Was there any discussion about this pending divorce action?
He just said he wasn't gonna do anything.
Okay.
He didn't want the divorce.
So is the home on France Street, is it vacant?
It is right now, yes.
Okay, did you go in there just to make sure it's secure and everything?
I did.
Okay, and so he's moved all of his property out of there?
Yes, sir.
Okay,
I have pictures if you need it.
no, not necessary.
Okay.
Well, the record to reflect this matter was scheduled for 9:30. It's now almost 9:45. Mr. Johnson has not appeared. He's not contacted the court. I'm sorry, when did you last stop by the house, Ms. Johnson?
It was about a week ago.
Okay, was there mail being piled up at the home?
No, but it goes to a box and I don't have the key to it.
Okay, so his mail is being forwarded?
My mail is being forwarded to me.
Okay, but was there a pile of mail in his name?
Not that I'm aware of.
Okay. The matter was scheduled for 9:30 this morning. It's now 9:45. Mr. Johnson has not appeared. He's not contacted the court. The record should also reflect that personal service of the summons and complaint was made upon Mr. Johnson back on February 6, 2024. The clerk entered a default on March 18th, 2024. Copy that default along with notice of hearing of the plaintiff's motion for entry of default judgment. It was all mailed to Mr. Johnson as his last known address. That is the address to which he was personally served with the summons complaint for divorce. The court's mailing to Mr. Johnson of notice for today's pretrial conference has not been returned as being undeliverable. That was also mailed to Mr. Johnson at his last known address of 8. So it appears that we are in a position to proceed with this default to judgment, Ms. Trout. I thank you. Right, Ms. Trout, you can proceed with Ms. Johnson, please.
Sure, Your Honor, and just as a preliminary matter, none of our mail has been returned either.
Thank you.
Okay, so, excuse me, Ms. Johnson, did you file a complaint for divorce?
I did.
And the allegations you made in that complaint, were they true when you made?
Yes.
Do they remain true today?
Yes.
If the judge did not grant you a divorce today, would you live, excuse me, with Mr. Johnson again as husband and wife?
No.
Are you currently pregnant?
No.
And you have read the terms in this default judgment of divorce?
Yes, ma'am.
And where you say in the default is there's no spousal support awarded to either one of you?
Correct.
And that there is a interest in a real estate at 84 Michigan?
Yes, we have to do something.
Yes, and then in the default, you will be putting that up for sale?
Yes.
And vehicles, you are currently in possession of a 2024 Honda,
Yes.
and you want that to be awarded to you free and clear of any interest, Mr. Johnson?
Correct.
And as far as you know, Mr. Johnson has a 2014 Ford Flex. And
Yes.
he would be awarded that free and clear of any interest from you?
Yes.
And the bank accounts, and all your bank accounts in your name will go to you in the bank accounts, and his name will remain with him.
Yes, ma'am.
And then you will split the debt for the Lowe's credit card,
Yes.
50-50.
Mm-hmm.
And that's as of today, what's on that card today.
Yes, ma'am.
And retirement account, you will be retaining your retirement account, and he will retain his retirement account if he has any.
Correct.
And you want your name restored to Elizabeth L.
Yes, ma'am.
Your Honor, I have no further questions.
Thank you, Ms. Trout. Ms. Johnson, were there any children born to you and Mr.
No.
Johnson during your marriage relationship?
No, sir.
Okay. The court notes from the proposed judgment that the primary asset is the real estate, the former marital home on France Street. Have you been able to monitor whether or not the mortgage payments are being paid?
I was for a while there, but then I guess he called and had the email switched, so I couldn't log into it. So I have not been able to move forward with that.
The court suggests you may want to contact the lender and also check with the Frenchtown Township, make sure the taxes are being paid. You don't want to
Okay.
obviously jeopardize your interest in this home, you get it listed on the market as soon as possible. Judgment does provide that the defendant will keep the mortgages and utilities updated and paid, but again, he may not be doing that. So court strongly suggests you want to protect your own interests. Is Mr. Johnson employed or is he retired?
He's on, he gets disability.
Disability, okay. Well, you definitely want to protect your own interests with this real estate, and especially you don't want it to go into foreclosure, even if you have to start making the payments, get it on the market as soon as possible so you don't jeopardize your interest in this property.
Yes, sir.
You can always, of course, secure reimbursement of your interest to the extent that you've made these mortgage payments from the proceeds.
Okay.
All right. Thank you, Ms. Trout. Based upon the testimony that's been presented this morning, as well as the complaint filed, this case court finds that jurisdiction has been established. Court further finds that there has been a breakdown of the marriage relationship to the extent that the obvious matrimony has been destroyed. There appears to be no reasonable likelihood that the marriage can be preserved. Accordingly, upon receipt of the judgment, the court will sign that judgment by default and order that the marriage between the parties be dissolved, and judgment shall enter granting a divorce from bonds matrimony. Of course, Ms. Johnson, when you receive a copy of the judgment, you got to take a copy to the Secretary of State and Social Security to facilitate the legal change of her last name. Ms. Trout, the proposed judgment was actually attached to your motion, so it's a part of the court file. So if you can send to the court another copy of that along with additional copies, so the court can sign that and send back true copies.
Okay, yes, Jan, should I send it through the, I don't do the filing here, my parents do you send it through the electronic filing system or directly email to the court?
No, neither. The county, Monroe County is not yet on an e-filing system, and they will not accept emailed copies. So you just got to stick them in the mail.
Okay, all right.
Hard copies.
Not a problem. All right, thank you.
I would suggest probably you probably want the original 3 copies, so that the original copy will be signed by the court, put in the court file. 3 copies will be returned to you, 1 for your file, 1 for Ms. Johnson, 1 you can mail to Mr. Johnson.
Thank you, Your Honor. I will.
Right. Thank you, Ms. Trout. Good luck to Ms.
Johnson.
Well, it's going to be, I'm sorry.
All right.
Houston.
Houston. Good luck to Miss Houston.
All right.
Thank you, Ms. Trout. Have a good rest of the day. You can zoom out.
Okay, thank you. Bye-bye.
You're welcome.
Bye-bye.
That Nellie Rushlow is out in the hallway, just so you know.
Okay. Did she make a payment? Nope.
Not the full payment.
For the record, both files are before this court this morning. First of all, there's a personal protection order filed, and a motion to terminate the PPO has been filed on behalf of the respondent, Michael Yench. In addition, the other case, which is a pending divorce complaint, is before the court for a pretrial conference. And it's like conflicting orders, motions for to show cause for alleged violations of a mutual restraining order. In any event, this hearing is being conducted via Zoom. Present is Attorney Allison Fulmar, representing the plaintiff, Michael Yench Jr. Good morning, Ms. Fulmar.
Good morning, Your Honor, and may it please this honorable court. Allison Fulmar, P 60236, appearing on behalf of Mr. Michael Yench. Please state your name for the record, Mr. Yench.
Hello, Michael Yench Jr.
Thank you. Good morning. In addition, Attorney Kirsten Nemec is present representing the defendant, Robin Yench, and Ms. Yench appears to be present. Good morning, Ms. Nemec.
Good morning, Your Honor.
The parties have conferred with Mr. Walker in front of the court. Mr. Walker has provided the court with a fine recommendation that the personal protection order in case 2024-147403 PP be terminated. Further, the parties have agreed to mediate with Mr. Walker on June 10th, 2024 at 8:30 a.m. via Zoom. Further, it's recommended that the court order that all boats and vehicles not currently in use and owned by the parties shall remain in their current location and current condition until further order of the court. If either party is in possession of the 1974 Honda mini bike, they shall immediately return it to the marital home garage. All utilities associated with the marital home shall remain active and turned on until further order of the court. If a second LS motor, I'm not sure what LS motor is, if a second LS motor exists, then it will remain where it is currently until further order of the court. Further, that as soon as the parts that have been ordered for the 1987 Chevy R30 are received, they will be installed. That's the recommendation this morning.
Yes.
Ms. Fulmar, is this recommendation agreeable with your client?
It is, Your Honor. I'm happy to announce that we have made a resolution that is agreeable in this matter on all matters.
Wonderful, thank you. And if necessary, the court's position on its PPOs is that to be terminated. If the parties believe it's necessary, someone always compare prepare a mutual restraining order in the DO case, the divorce case with the same language. The only difference would be there's no immediate arrest on the alleged violation. So if in fact the parties feel we're still under a mutual restraining order, that such an order can then be entered by consent in the DO case. That's court suggestion, but in any event, Ms. Nemec, is your client agree with this recommendation?
Yes, Your Honor, she is.
Okay, the court will need an order terminating the PPO. And who can prepare that order?
I will, Your Honor.
Fulmer?
Yes.
Okay, very well. Well, there looks like my staff's already prepared an order. I can enter this order, terminate the PPO, and I can just make note that pursuant to agreement of the parties on the record today, that would minimize further effort and expense on your client's part, if that's agreeable.
That's what with me.
So we can terminate the PPO today then, correct?
Yes, Your Honor, thank you.
Right. The court will enter an order to that effect. I've got a standard SCAO approved form order, so the court will enter that order. All right. What the court will also do is schedule a continued pretrial conference on June 10th, immediately following that 8:30 mediation with Mr. Walker. Is it possible we can take the proofs today? The court will reserve all outstanding issues. We can stop the court's time performance guideline clock.
I have no objection to that. Mr. Yench is the plaintiff.
Any objection, Ms. Fulmer, taking the proofs to establish just a jurisdiction there's been a breakdown?
Yes, we
reserve
can
all outstanding issues.
Yes, we can do that, Your Honor.
Right.
Your Honor, may I have like 30 seconds or less just to explain that to my client?
Certainly.
Okay, I just need.
Or the court can explain it. Either one. Okay.
No, I'm satisfied with the court's explanation. Just.
All right, Mr. and Mrs. Yench, the Michigan Supreme Court has set time frames for courts to resolve actions of this nature. So I'm under a time frame, and this mediation is not till June. So the court can stop its clock. I don't need to rush things and push things to an early mediation date. If we take some brief testimony that number one, that the jurisdiction has been established, there's been a breakdown of the marriage, no chance of reconciliation, there's no minor children, and Ms. Yench is not pregnant. That's all I need to establish by some testimony this morning to stop the court's clock. It'll give us everyone more breathing room and flexibility from a time perspective. Do either of you have any objection to the court doing so?
No, I don't, no.
No, Your
Not
Honor.
make any decisions? Okay. All right, Mr. and Mrs. Yench, can you both please raise your right hand to be sworn, please? Mr. Yench?
Yes.
Yes,
There you go. Thank you. All right, so Ms. Fulmer, if you want to begin to establish jurisdiction, there's been a breakdown from Mr. Yench, take the proofs essentially, and then you can confirm with him his understanding of this agreement, please.
Yes, very well. Mr. Yench, you came to me in my office for the purposes of filing a complaint for divorce in this matter. Is that correct? You can speak up.
yes,
Okay, and at the time that we filed the complaint, or you did that previously
Yes.
with a previous counsel? Okay, and at that time, did you live in the state of Michigan for at least 6 months and in Monroe County for at least 10 days prior to filing the complaint?
yes, I have.
And did you review the allegations in the complaint for divorce?
Yes,
Okay, and were they true at that time?
yes,
And are they true today?
yes,
And if Judge Braunlich did not grant for whatever reason, grant you a judgment of divorce, would you live together as husband and wife ever again with Miss Robin Yench?
absolutely no,
Okay, and do you know her to be pregnant at this time?
no.
Okay, I'm
She
satisfied, Your
cannot
Honor. I'm satisfied, Your Honor.
All right, did you want to write Mr. Fulmer on this recommendation, this agreement, Ms. Fulmer?
Yes, so preliminarily, we have an agreement with respect to the motions that were up for today, which is the termination of the PPO. You filed a show cause, Mrs. Yench filed a show cause, and I asked for an adjournment of the mediation. You were aware of that?
Yes,
Okay, and we met with Mr. Walker and had conversations with the defendant and her counsel. And do you feel that as though it's a fair resolution of those motions that were pending for today?
yes,
And you will agree to abide by what we came up with today?
Yes.
That the judge is going to place as an order?
yes.
Okay, I'm satisfied. Your Honor.
All right, thank you, Ms. Fulmer. Ms. Nemick, do you have any questions, first of all, for Mr. Yench?
Just one clarification. Mr. Yench, you understand that with regard to, the part of the order that states that, any vehicle that's not currently in use would stay exactly where it is. That means nobody's going to be driving them, correct? Or
Correct.
boat. I guess you drive a boat too as well. So driving would be correct.
No,
Yes.
I don't have any
He's-
boats to drive.
Yeah, he's indicated that.
I have nothing further, Your Honor.
So in other words, Ms. Nemick, Ms. Fulmer, no boats will be put in the water?
Well, we didn't say that.
Right.
We didn't say that. That was not a part of the agreement, that no boats would be put in the water. It said that all boats currently not in use, owned by the party, shall remain in their current location.
And it was my understanding that we clarified that language with Mr. Walker to mean that both vehicles, all vehicles, including boats, would remain literally where they are. That was
Yeah, yes, but we never, ever uttered one word about not, we specifically said the truck, the 1987 truck would not be driven, but no one raised an issue with respect to the boats at all.
She has a boat.
Don't say anything.
okay. I believe that there are some boats in Mr. Yench's possession. And if we have an agreement that all boats will remain all vehicles will remain where they are, then if they're not currently in the water, then they couldn't be put in the water. Right?
We
So
never.
are the boats in the water? Are there any boats in the water right now?
No.
I don't mean to open a can of worms. I'm just trying to make sure everyone's on the same page.
Well, the same would be true. I mean, Mrs. Yench has indicated that she does have 2 boats. So it's
Okay.
the same. It's
Correct.
mutual.
Okay, so
Correct.
what is, so in other words, will the boats, are the parties allowed to put the boats in their possession in the water or not?
My understanding was no, that they have to literally remain wherever they are.
Right, I've got a couple parties waiting for me. I'm gonna talk with Mr. Walker again. You can try, I want this clarified before we go any further. If necessary, the court will make that decision. I got other parties waiting,
Yeah.
so I'm gonna put you into break on with Mr. Walker.
Your Honor, that was the intent of my recommendation, was that the vehicles and the boats remain exactly where they are and not be used. So there's no point in putting them in the water if you're not going to be able to use them. You will not move them at all. That was my intent.
Okay,
We have no objection to that. It's just that was not the boat specifically not being put in the water specifically. My client has indicated he has no intention on putting any boat. We don't even have a boat.
Yeah, I don't have the boat to put in the water. She's got the boat.
She has 2 of the boats. And so
okay,
it's
so
no
Ms.
problem.
Plumar, it's not an issue then. We can agree and
Yes.
clarify that the boat, none of the boats will be placed in the water until further order. Is that correct?
Correct.
All
That
right,
would be
okay,
the cigarette boat too, right? All of his boats that are in his possession. That would be a cigarette boat, the jet boat, anything like that. I just want to make sure, because it's just me having the boats as being said. So I just want to make sure it's every single boat that we have owned prior, or, he had the cigarette boat prior, but it's still part of the marriage.
See, we didn't talk about that.
All right, I'm gonna, I've got matters waiting right now. Somebody have talked with Mr. Walker and I'll have you back before noon. Okay, put you back in our room and talk about it, please. If not, the court will make a decision this morning. Are you Mikhail Redwood?
Yes, Your Honor.
Record, Mr. Redwood is appearing via Zoom from the Monroe County Jail. Also present for the Zoom hearing is Monroe County Front Attorney Rebecca Hicks. Ms. Hicks, can you provide the court some information regarding Mr. Redwood, please?
Yes, certainly, Your Honor. In this matter, there is a current monthly support obligation of $483 per month. The current arrears balance is $2,166.98. The current bench warrant resulted when the respondent failed to appear at a show cause hearing with referee McKee on January 18th of 2024. After no objection was filed regarding that bench warrant, it went on lien on February 23rd of 2024. The last voluntary payment on this case was made with an employer IWN in November of 2023. So at this time, the friend of the court is requesting a finding of contempt against Mr. Redwood, Your Honor.
All right, Mr. Redwood, first of all, are you being held on any criminal charges or only just a friend of the court bench warrant?
Just the front of the court bench warrant, Your Honor.
All right, Mr. Redwood, why don't you state your current address for the record? If you're not keeping front of the court informed of your address and you're being mailed notices, you're not appearing, that's why bench warrants issued. So why don't you state your current address for the record?
174.
How do you spell Bordeaux?
BORDEAU. Street.
Thank you. Is that the address you have in file, Ms. Hicks?
Yes, it is, Your Honor.
All right, well, you're not checking your mail, Mr. Redwood. Anyway, Mr. Redwood, you're being charged this morning with civil contempt of court for failure to pay child support. It's punishable by up to 45 days in jail. Since there's possibility of jail, you have the right to an attorney. If you're unable to afford an attorney, the court will appoint an attorney to represent you at public expense. Are you asking for a court-appointed lawyer?
If possible, please.
All right. Why don't you give me a cell number in case you post bond? The attorney can reach you by his cell number. So why don't you give me a cell phone number, please?
73.
Hey, are you currently employed, Mr. Redwood?
Yes, I just started a job trying to pay this because I did get the mail for all this. I was 3 months in a depressed state of not being able to get a job.
What's the name of your employer?
My name of the employer is Target Steel on Freeland in Flat Rock.
How long have you worked for Target Steel?
I just started Tuesday.
Okay. Is this a full-time job, do you expect?
Yes, it is 50 hours.
Okay. Do you own any, do you have any bank accounts?
I have I don't know if app related ones count, but a real bank, Fifth Third Banking.
How much do you have in your bank account?
Probably like $20, and that's for gas.
All right. You own any property of any value? A snowmobile, motorcycle, vehicles?
Just a 2009 Dodge Avenger that has a busted headlight is why I got caught up here. All
right. The court grants your request for court-appointed attorney. This is a Friday, so the court's going to set this for hearing on Monday morning, 11:15. You order to appear. Your attorney will reach out to you. That is April 22nd, 11:15 a.m. If you're in jail, it'll be via Zoom. If you post bond over the weekend, you need to appear in person, Mr. Redwood. What kind of bond are you recommending? Ms. Hicks, probably a minimum of $500.
Yes, Your Honor, $500 was the request of the front of the court.
All right, so Mr. Redwood, you order to, the court's required you post a $500 cash bond. So reach out to family and friends. If they can post that bond, you'll be released this afternoon, go home for dinner. You can pay them back, and that bond will be applied 100% toward your wages. It's going to benefit you. You can pay them back when you get your first paycheck. Not allowed to keep the job, but it's $500. It's not overwhelming, and we want you to keep that job. Do you anticipate working on Monday?
I really wish I could. I've tried calling everyone that I could to come get me. Yes,
assuming you post
at 1
bond.
o'clock.
All right, so I'll tell you what, 1 o'clock?
Yes, sir. Or yes, Your Honor. Sorry.
You work afternoons?
Yes, 1 to 12 at night.
All right. Ms. Hicks, do you have any objection if in fact he posts bond, they can appear by Zoom on Monday?
No, I would not have any objection to that, Your Honor.
All right. So since you live up in Romulus and you work, Mr. Redwood, you can appear by Zoom. We're going to put in this order that with the court's Zoom ID number, you can appear by Zoom at home or at work in your vehicle. You don't need to drive down to Monroe if you post this bond. Okay.
Thank you, Your Honor. Can I do a payment for the bond part?
It said doesn't work.
All my money is at home in cash.
Yeah. So reach out to someone. They can post $500 cash. You can be home for dinner tonight. So make some phone calls. And this matter will be, you'll have your court-appointed attorney reach out to you, will talk to you by phone if you post bond. If not, they'll talk to you by Zoom in the county jail before Monday at 11:15.
Thank you, Your Honor.
So it can appear by Zoom. Any other questions, sir?
I just hope I can get out soon so I can keep this job.
Yep. Make some phone calls, family, friends. All right, so you can step out. A copy of this order will be faxed over to the jail. And you'll get a copy of that before you're released in terms of the $500 bond, and the matter set for Zoom hearing on Monday, April 22nd, 11:15 a.m. You can step out, sir.
Later, I'm your attorney. I've made several attempts to contact you, but it always says that your phone number is not working or something. So.
Yes, my phone was deactivated on the 20th due to inefficient funds.
Understand fully well. So is there a way that you can maybe call me? Either that
breakout room. I was gonna say, Sarah, will you just put them in a breakout room and give them the opportunity to talk for a minute?
That would be perfect. Thank you so much.
Hello?
We got you. We're just waiting for the judge.
Oh, okay.
Are you present in audio?
Yes, I believe so.
Okay, well, what's your name, sir?
Michael Redwood.
Okay, you are present in audio. Okay, we can hear you. Also present this morning is Monroe County Front of the Court Attorney Rebecca Hicks and Court Appointed Attorney Timothy Ryder. Good morning, Mr. Ryder, Ms. Hicks.
Good morning, sir.
Obviously, the court would assume that since Mr. Redwood is appearing by audio, then he did post a $500 cash bond over the weekend. Is that correct, Ms. Hicks?
Yes, that is correct, Your Honor.
Okay, and he was working, so the court told me he could appear via Zoom. Mr. Ryder, have you had a chance to discuss this matter with Mr. Redwood?
Your Honor, I've had a chance to talk with both Mr. Redwood and Ms. Hicks. We do have a resolution. I conveyed that to Mr. Redwood, and I would let Ms. Hicks place that on the record.
Ms. Hicks?
Yes, Your Honor. With Mr. Redwood admitting to contempt, the front of the court is not asking for any immediate jail. We would ask that the $500 bond be forfeited on his arrears, and the front of the court would set this matter out for review on June 18th at 10 a.m. And we've sent an income withholding notice to his new employer that he provided on Friday.
Thank you. Mr. Redwood, are you satisfied, first of all, that you received the right to legal counsel by conferring with Mr. Ryder?
Yes, Your Honor.
You heard the agreement placed upon the record by the front of the court attorney, Ms. Hicks. Is that correct?
Correct, Your Honor.
So in essence, the court filed a recommendation. If you admit to contempt this morning, the court would impose a sentence of 45 days, but the court would suspend that sentence. In other words, I'll give you the key to the jail. You would not serve one day of those 45 days unless you failed to comply with the orders of this court in terms of appearing when required and paying child support. You understand all that?
Yes, Your Honor.
Mr. Redwood, do you understand that if you admit to contempt this morning, there will be no hearing or testimony other than your own? Do you understand that?
Yes, Your Honor.
All right, Mr. Redwood, can you raise your right hand to be sworn? Help you God. Do you sound?
Yes, Your Honor.
Mr. Redwood, please state your name and current address for the record.
Michael Redwood 4.
Thank you. Mr. Redwood, do you admit and acknowledge that you are obligated to pay support for the support and maintenance of children born to you and Amanda Grabowski?
Yes, Your Honor.
You admit and acknowledge you have outstanding arrears of about $2,000.
Yes, Your Honor.
You admit and acknowledge you've not made any payments until just recently. You've not made any payments since November of 2023.
Yes, Your Honor.
Have you had any income since November of 2023?
No, Your Honor.
How did you support yourself then for the last 5 months?
For the first 3 months, I've been sleeping in my car, and just recently I've found a stable place to stay, and she lets me work around the house for her. She's kind of an elderly lady right now, and I'm getting everything in for the mailing. I've just been cleaning up and trying to make it stable and get workflow first before mailing everything to me.
Okay. Were you disabled from and after November of 2023?
No, just a family event that allowed me to not stay where I was at that time anymore.
All right. Mr. Ryder, do you have any questions of Mr. Redwood?
No, I don't, Your Honor.
Ms. Hicks, do you have any questions, Mr. Redwood?
No, I do not, Your Honor.
Well, based upon the testimony of Mr. Redwood, that he was not disabled, capable of employment, but simply was not motivated to pursue gainful, meaningful employment where he had income from and after November 2023, didn't appear at the front of the court, was not cognizant of this obligation. His lack of due diligence in addressing this obligation, this order of the court, is the basis for contempt. The court will qualify Mr. Redwood to be in contempt of court. Mr. Redwood, you do admit and acknowledge that you ordered to pay $483 a month, and you didn't do that for a number of months. Is that correct?
Yes, Your Honor.
All right. The court finds that there's a sufficient factual basis to support Mr. Finding of contempt on part of Mr. Redwood. The court will accordingly find Mr. Redwood to be in contempt of court. Mr. Redwood, is there anything you want to say before the court imposes sentence?
If I can talk to my lawyer afterwards to understand the legality of everything that's happening, then moving forward.
Well, you probably want to talk to your attorney now rather than afterwards. What the court's going to do, the court's going to impose a suspended jail sentence and order you to appear before Ms. Hicks June 18th. Is As long as you appear in that date, you make payments between now and then, you're gonna avoid any jail.
Okay.
Any other questions? Mr. Redwood, do you have any other questions?
No, Your Honor. I'm sorry.
All right, the court's going to order Mr. Redwood to serve 45 days in Rogue County Jail. That sentence, however, will be reserved. The $500 bond posted by Mr. Redwood shall be forfeited to apply toward the verges. Mr. Redwood, you'll be mailed a notice to appear before Ms. Hicks, June 18th, 2024 at 10 a.m. for a Zoom hearing. Now, all she's going to do is just make sure you make some payments. If you get injured at work, you lose your job, you contact the front of the court, be proactive, and you can avoid, even though you don't have the income to pay, there's things you can do. You can file a motion to reduce your support. Just be proactive. Do not ignore, don't sit on your hands. That's the worst thing you can do, all right?
Yes, Your Honor, and I'm sorry.
Okay, Ms. Hicks, anything further?
Nothing further, Your Honor. I'll prepare that order and upload it to your queue.
Okay, Mr. Redwood, do you still want to talk with Mr. Ryder this morning?
No, I believe I understand everything that's going on.
Okay, he will not be appearing on June 18th. No need to. If in fact you're moving towards some jail, you can ask at that time to confer with an attorney. But you hold the key to the jail, Mr. Redwood. Simply be proactive, take care of this obligation. You need to pay that 43 month, and if your income from Target Steel is not enough to pay that and some toward the verges, you need to file a motion to reduce your support. Understood? Be proactive.
Understood, Your Honor.
All right, Mr. Redwood, you are all set. You can zoom out. Have a good rest of the day. Thank you, Mr. Ryder.
Thank you, Your Honor.
Thank you, Judge.
Okay, I think we also have Nellie Rushlow. Did Ms. Rushlow make a payment this morning?
Let me see, Your Honor. I'm currently in Mr. Redwood's. Let me go to hers now.
Okay, we're gonna have Ms. Rushlow come into the courtroom. Okay, we can call the case. Are you Nestle Rushlow?
Yes, I am.
All right, Ms. Rushlow, were you able to make a payment this morning?
Yes, I was.
Okay, and how much?
My monthly application, $113.
Okay, the court suggested you pay $500.
I wasn't able to come up with that.
Okay, ma'am, sir, could you step outside with the child, please? Go to the same door you came in, please. Ms. Rushlow indicated she did not make the $500 as suggested by the court. She's got 14 days jail hanging over her head.
Yes, Your
She
Honor.
paid, I think, $100.
Miss Rushlow did contact me and let me know that she was having difficulty coming up with the $500. I had asked her at a minimum to try and come up with her current support obligation, as that had been what I had wanted her to pay prior to her hearing on Tuesday, and she failed to, which is what elevated it. I do see she made a payment of $115 and current support is $113, Your Honor. So she did at least cover her current support, which is what the front of the court had originally requested of her prior to her hearing on Tuesday. So the front of the court would not be opposed to doing a short adjournment to monitor that she can continue making her current support obligation going forward.
The court notes she's got a rear is almost $6,000, which are not going to go away, Ms. Rushlow. So, yeah, with court will follow the recommendation of Ms. Hicks. Typically, I would send you to jail for not paying the $500, but you've done something. But keep in mind, you've got to pay more than the $113 a month. And if you can't afford the $113 a month, file a motion to reduce your support.
I'm gonna go, like, if you were to let me go home, I was gonna go downstairs.
Okay, you can get a packet, a support packet. All right, so the court will follow Ms. Hicks' recommendation. We'll adjourn this matter. And just keep contact with the front of the court. And just be proactive. That's what I want you to do.
Would I be able to do like community service?
No, it used to be, but not anymore because this is child support. Yeah. There's no interest or any fees being added, but unless Mr. White agreed to waive some of these arrearages, that's only a possibility. So what do you suggest for an adjourned date, Ms. Hicks?
June 4th at 8 a.m., Your Honor.
And what you're expecting that she will make a payment in May as well as June, minimally the 113 between now and then, correct?
Correct, for May's payment.
All right, Ms. Rushlow, you're ordered to appear before Ms. Hicks, June 4th at 8 a.m. Hopefully you'll not be brought back before this court because you got 14 days to have your head. So you hold the key to the jail. You can avoid that by simply paying the minimum of the 113 a month. And I suggest, let's do the first month. I suggest you pay that for May and June. And come back. And stop down in front of the court on your way out and pick up a support packet. Be proactive. Anything further this morning, Ms. Hicks?
Nothing further on this, Your Honor.
Okay, all right, you're all set, Ms. Rusher, you're all set to go. Have a good one today. Thanks for coming in. Thanks. Also, are back on the record in this matter, having again conferred with Mr. Walker to clarify whether or not boats and motor vehicles, other remaining where they are, if they can be used, or particularly boats being put in the water. Ms. Volmar, were you able to make any progress toward?
Yes, Your Honor. We just needed some clarification, but again, we stand by our agreement. It says all boats currently not in use owned by the party shall remain in their current location. So if they're currently disassembled or on dry land or wherever they are, they will remain. That's what we have agreed to. So
Okay.
yes, Your Honor.
So in other words, a boat that's on dry land will not go in the water, correct?
Absolutely, yes. And that's
Right.
covered by
So-
what's already stated.
Are there any boats in the water right now?
No, there are not.
Okay, it's still pretty early in the boating season, so none of those boats will be put, unless the parties can agree otherwise in writing, they will not go in the water. Maybe the parties can reach some agreement in the interim. They can still have that discussion. Rather than wait until June 10th, the boating season is pretty short here in Michigan. It's 3 months.
Yes.
The court just wanted clarification of that. Ms. Nimick, that's your understanding that any motor vehicles and watercraft will not be removed from their existing location. If they're on the boats or on land, they will not be put in the water until further order or an agreement of the parties in writing. Is that correct?
That is correct, with the exception of the 2 vehicles each party has. So each party has 2, 4 total, that are currently in use. And there's an understanding of which vehicles they are and who's using them. But other than those 4, everything else will remain where it's currently located.
Do we need to identify for the record those vehicles?
I don't think it's necessary, Your Honor. Mr. Yench has 2, Ms. Yench has 2. They're the vehicles that they use daily or every other day. They're currently in use.
All right. I'm trying to think where we left off. Ms. Nimick, did you have any other questions of Mr. Yench regarding this agreement?
Nope, that was my only question. Thank you, Your Honor.
Okay. All right, the court would like to also send out just a pretrial, complete a pretrial statement in terms of the issues. Are the parties separated? Or are they still living together?
They're separate, Your Honor.
They are separated.
Okay.
Your Honor, may I voir dire Ms. Yench?
Oh, yes, I'm sorry. Yes, I got off track. Please, Ms. Nimick.
That's okay. Thank you, Your Honor. Robin, can you state your name for the record?
Robin Yench.
And you are the defendant in this action for divorce, correct?
Correct.
Okay. You heard the statements that Mr. Yench placed on the record with regard to having lived in the state of Michigan and the county of Monroe prior to filing the complaint for divorce, correct?
Correct.
And were those statements accurate to the best of your knowledge?
Yes.
Are you currently pregnant?
No.
Do you agree that there's been a breakdown of the marriage to the extent that the objects of matrimony have been destroyed and there remains no likelihood that the marriage can be preserved?
Correct.
Okay. You also heard the agreement or the recommendation of Mr. Walker that Judge Braunlich read into the record.
Correct.
Okay. Did you understand all of it?
Yes.
And you agree to those conditions?
Yes.
Okay. Did you have any questions about it?
Not that I know of. Mm-mm.
Okay.
No.
And is anybody forcing you to enter into it?
No.
I have nothing further, Your Honor.
Thank you. Ms. Volmar, do you have any questions, Ms. Yench?
I do not, Your Honor. Thank you.
Well, with respect to completing a pretrial statement, the court's going to, of course, order that a continued pretrial conference to be conducted on June 10th after the 8:30 mediation with Mr. Walker. In terms of the issues, obviously, it's personal property division. Is there real estate to be divided as well, Ms. Volmar, Ms. Nimick?
That remains open, an open question, yes.
Yes, Your Honor.
Okay. Retirement benefits?
Yes,
It's a pretty short-term marriage, 3-year marriage, but do you want me to check that as a possible issue?
Possibly, yes.
Okay. Is there a significant unsecured debt that needs to be divided, like credit card debt?
There is debt. I don't believe it's significant, but there is.
I agree.
Okay, I'll mark. So I'm going to note personal property, real property division, pension benefits, and unsecured debt. The court will leave discovery open. So if the parties need to submit some, hopefully discovery can be completed so that everyone's prepared to mediate. It's effective on June 10th. In terms of the marital home, if parties are separated, there's nothing do we need to address whether the other party who's not living there can enter the home?
We have addressed that, Your Honor. My client, since Mrs. Yench has vacated the marital home approximately 2 weeks ago. My client has re-entered and retaken the property exclusively. I was going to file a motion for exclusive use of the marital home, but according to Mrs. Nemec, that was not necessary. It's my understanding that Mrs. Yench has no intention on returning to the marital home. So with that understanding, yes, my client is exclusively using the marital home.
Okay. Ms. Nemec?
Your Honor, I would have to ask Ms. Yench, while she does not have an intention to return to the marital home to live there, I don't know that she has every item of property that she needs. So Ms. Yench, no, okay. Is there anything that you would need to return to the home to retrieve prior to our next mediation?
Currently, no.
Okay.
It can wait till later on.
So we can agree that she's not going to return to the home for any reason between now and the mediation.
Well, yeah, I guess maybe, Your Honor, we didn't discuss that, but I don't know if that can be added, but I don't want, we just got rid of a PPO that we took multiple issues with. So I don't want Mrs. I'm sorry, please pardon me, Mrs. Yench to just arbitrarily show up stating she forgot something at the house, unbeknownst to my client. The PPO is set aside, but these parties do not need to have any contact at all. So we just.
I will not.
Ms. Yench has already indicated that she won't be returning to the home and that she doesn't believe that there's anything that she needs from the home right now. In addition, Mr. Yench is under bond conditions that prevent his contact with Ms. Yench. So.
Well, he's not the one reaching out to her, so.
She hasn't reached out to him. I'm just saying.
All right, the court's not trying to create an issue. I'm just asking, make an inquiry because I've been trying to avoid issues of conflict. So if there's no objection, we have Mr. Walker add a sentence to this recommendation that the plaintiff, Mike Yench, is awarded exclusive use of the marital home. So in other words, Ms. Yench should not go there without his permission.
There's no
without his consent. Ms. Walker, he just maybe, and I understand this is a form, maybe even under the parenting time, you just put in some language in there that plaintiff has granted exclusive use of the marital home. So Ms. Yench can't go by there without getting Mr. Yench's approval ahead of time. And obviously, no one's going to remove any property. If there's something you want from the home, that will be preserved and that can be addressed at a later time. So we'll just add that to, don't need any additional orders. So Mr. Walker, be kind enough to add that to this recommendation.
We'll do that.
Mr. Walker, for your efforts this morning. So we're going to add that to this order. And is there anything further than this morning, Ms. Fulmar and Ms. Nemec?
No, Your Honor, not on behalf of the plaintiff. Thank you so very much.
I have nothing further. Thank you.
And there's no reason why council cannot confer in the meantime. Maybe they can address some of these boats. As the court stated, it's a short boating season. If in fact they've agreed that certain boats are awarded one party and that person can put the boat in the water, and the court would encourage that. Otherwise, we will address these issues on June 10th. All right. Thank you, Ms. Volmar, Ms. Nemec, Mr. Walker. That will conclude the court will also enter an order today terminating that PPO. So that'll be entered today. That'll be served with the sheriff's department to remove from lien.
Thank you, Your Honor.
Thank you very much.
Right. Thank you all. That'll conclude
Have
this
a
matter.
great
Thank you, Mr.
weekend,
Walker.
everyone. Thank
You
you.
too.
You and your staff, Your Honor. Thank you.
For the record, this matter is before the court for a pretrial conference. The same is being conducted via Zoom. Are you Anthony Caruso?
Yes, sir.
Ma'am, you're Morgan Caruso?
Yes.
Good afternoon. Court is in receipt of a proposed consent judgment of divorce. Everything appears to be in order. Can you both please raise your right hand to be sworn? Do you both solemnly swear or affirm that the testimony you're about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Yes.
Thank you. It's wonderful everyone's putting together today. Very unusual. Must be the spring weather.
You don't see that too often.
No, that's exactly right. All right, we can start with you, Mr. Caruso. You're the plaintiff. Can you please state your name and current mailing address?
My name is Anthony Terry Caruso, and I'm at.
Thank you. Mr. Caruso, is it true that you filed a complaint for divorce with this court on about January 24th, 2024?
Yes, sir.
Is it further true that on the date you filed the complaint that you reside in the state of Michigan at least 6 months and the county of Monroe at least 10 days?
Yes, sir.
Further true that you married Morgan Swatecki, now known as Caruso, on September 22nd, 2018?
Yes, sir.
Is it true there's been a breakdown of your marriage relationship to the extent that the objects of matrimony have been destroyed and there's no reasonable chance of reconciliation?
Yes, sir.
Were there any children born or adopted during your marriage who are still minors?
No.
Did you in fact sign your name to this proposed judgment approving the terms and conditions contained therein?
Yes.
All right. Ma'am, could you please state your name and address for the record?
Morgan Caruso?
Okay. So you're still living together?
Yes.
Ms. Caruso, did you hear the testimony of your husband, Anthony, this afternoon?
Excuse me?
Morgan, did you hear the testimony of your husband, Anthony, this afternoon?
Yeah. Yes, I did.
Was his testimony true and accurate to the best of your knowledge?
Yes.
Pregnant?
No.
Did you sign your name to this proposed judgment?
Yes.
I'm sorry, did you have a question about the last question? It's necessary. The court, even if you're 70 years old, I have to ask you whether or not you're pregnant.
Yeah, I wasn't sure if that's what you said, but no, I'm not pregnant.
Thank you. If so, that would delay entry of the judgment. But in any event, so that's the answer of the court's open to see. Ms. Caruso, you also signed your name to this proposed judgment, correct?
I did.
All right, I'm going to walk through the terms of this with both of you. You've agreed that you're married about 5 years. Spousal support is not awarded. That's forever barred. You've already they're still living together, but what about personal property? This judgment says each of you is awarded the personal property currently in your possession. So when you split, are you going to be able to divide that?
Yes.
On your own?
Yes.
Okay.
Yes.
And there are no joint debts to be divided, correct?
Correct.
Is that correct?
Correct.
Okay. The judgment says there is real property to be divided according to the attached real property addendum. There is no real property addendum. Do you own the home that you're living in?
I do.
She does.
Okay. Typically, you would say that there is real property that's awarded to Morgan.
Correct. Yes.
It doesn't say that. There's no addendum. It doesn't say, it says there's no real property, but obviously you're both acknowledging on the record in open court that there is real estate and that is titled only in Morgan's name. Is that correct?
Yes.
What about the debt? Is that only in Morgan's name?
Yes.
Yes.
Right. That makes it clean. So,
Yeah.
If Anthony does not vacate upon the terms you agree, you're gonna have to evict him. You understand that, Ms. Morgan?
Yes.
Right. So I suppose we go with this. It's not totally accurate, but we note on the record that the real estate on Rutledge Drive, that's awarded to Ms. Caruso. And Anthony, you give up any right that you have in that. Arguably, you're entitled to 5 years of appreciated value, but half of 5 years of appreciated value. You're giving up any right you have in that real property. Is that correct?
Yes, sir.
You understand you can't come back and change your mind tomorrow or next week.
Yes, sir.
And if you don't vacate when Morgan wants you to, then she'll have to start the eviction proceedings. Okay, and the judgment also provides there are no pensions or annuities or 401ks that are being divided. Is that correct?
No. Correct.
Correct.
So if you have any, you're going to keep your own.
Yes.
And finally, Morgan's last name of Swatecki will be restored to her. All right, so, Mr. Anthony, do you have any questions for the court?
No, sir.
Ms. Morgan, do you have any questions for the court?
No, I don't.
Very well, based upon the testimony that's been presented this afternoon, as well as plain file, this case, the court finds that jurisdiction has been established. Court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed. There appears to be no reasonable likelihood that the marriage can be preserved. Accordingly, it is ordered by this court that the marriage between the parties being as hereby dissolved and judgment shall enter, granting a divorce from the bonds of matrimony. Good luck to both of you. That will conclude this hearing, and the clerk will mail each of you a copy of this. And Ms. Morgan, when you get a copy of this, you have to take a copy to the Secretary of State and Social Security to facilitate the legal change of your last name.
Okay.
All right. Good luck to both of you. You can zoom out.
Thank you.
Sorry,
Thank you.
question?
That's it. Appreciate
All
it.
right.
Thank
Have
you.
a good weekend.